And we talk about intellectual property rights. And these are rights that are awarded by society to individuals, organization over creative works. And they give the creator the right to prevent others from making unauthorized use of their property for a limited period of time. We had given the example of the Coca-Cola secret ingredient, even the shape of that bottle, the KFC logo. These are intellectual properties that you can't just wake up in the morning and decide you're also going to copy them, so to speak. So we have patents, copyrights, and trademarks. And patents, it's a certificate that you get after you make an invention. And it's a juridical relationship between an inventor and the state on the other hand. You as the inventor, you're the one who brought out this new process or new invention, and you hold the right. So in Kenya, we have the Kenya Industrial Property Institute that registers and issues that certificate. And the criteria for a patent is that it must be new. It must not have existed before. We can think of Jiko Okoa. It's a new invention. While we have had the old Jikos in existence for the period of years we've been using them, this one was a new invention. And it must constitute an inventive step that must not be that obvious. You've gone further and modified or added a new twist to something. It must be industrially applicable and useful. It's not just for aesthetics. It's not for the beauty, and it's not for the sake of it. It must make an impact. And the impact must be felt not only by you, the creator, but by others. And this invention must not be excluded by statute. We're saying we don't want illegal inventions, or we don't want anything that will put people at risk. And KIPI has the discretion to grant or decline to award a patent. But where it is granted, there must be an application to register it. You disclose it to the state. And you're given that certificate for a limited period of time, mostly under 20 years, under the Trade-Related Intellectual Property Convention. And this patent can either be obtained by you as a natural person or a juristic person. A company may also be able to obtain it. And in this instance, we can think of Camry. If you're working under Camry and you discover something new, it's not you who will get that patent. The patent will be granted unto Camry, as long as you are doing it within the course of your work, within normal working hours, and you had agreed prior to making this new invention that your works, so to speak, belong to Camry. This is what we are saying. It may be granted to juristic persons. So inventions made in research institutions belong to those research institutions. They will not belong to you, even if you're the one who has discovered and you have done the hard work. As long as you do it in the course of your employment it belongs to that institution. So you as the patentee, your rights are to be granted a patent subject to the substantive and procedural legal requirements. You have the right to import, to sell, or to use the product covered. And you have the right to exclude others, outsiders now, from dealing with that product. And you're also given the right to exploit the patent through contractual licensing and assignment. And where it has been sold, you have the right to enjoy the royalties that will be received. You may have the rights, but you also have obligations. And one of the obligations is to disclose the invention to CIFA, and you give all the information concerning the applications, the grants. If you have been financed by a non-profit organization outside Kenya or within Kenya, then you have that obligation to report that you are being supported monetarily by another organization. You're also obligated to refrain from unfair, abusive, and uncompetitive terms and provisions in when you're granted this patent. You're prohibited from becoming abusive, becoming unfair, or doing business in uncompetitive terms, frustrating the rest of the business owners in that trade usage of yours. So you're prohibited from doing that. So when there's an unauthorized use or dealing with a patented product, which conduct will go against the claims, then a case on patent infringement may be brought. And if you're the one who has been found, then one of your defenses would be, it lacks novelty. It's not new. It's not something that is different from what we have been using. So you can't claim you have done something new, you've created something new. It would be a defense if I am found using the designs you used to create another jikokoa. And my defense would be, but it's not new. It's not something that is starting to exist. Rather, it has been in existence. And the remedies are normally injunctions, damages, account of profits, and delivery. So where you are told, if you are making these duplicate jikokoas, you are told by the court to stop and cease the actions that you're doing that will cause another harm. You may also be taken through the criminal sanctions way, but due to the fact that more often than not, when it comes to patents, when it comes to intellectual property, there is lack of or there's limited knowledge. Yes, limited knowledge on that bench. The magistrate to whom you're taking the case may not have the issues to be discussed as an expert. Say if you have a magistrate and you have an expert in those energy saving jikos, where you're not 100% sure of what is going on and what is making your design different from another's, it may be frustrating. But we also understand there are no experts per se. Theirs is through case law, through those following of those procedures. Having dealt with patents, now we can deal with copyrights. And copyrights are economic rights given to creators of literary and artistic works, and include the right to reproduce the work, make copies, perform or display the work publicly. And copyright law is intended to reward original expressions embodied in tangible material or fixed form. An idea does not infringe copyright, but once it is expressed in some form, it becomes tangible. And once it becomes tangible, then it can be misused or taken apart by another person. An idea is not tangible. So you cannot sue another person for stealing your idea, especially when it is not written down, where it is not, if it's in your head, there's no paperwork to show what you've been doing. It has not been converted from the idea to actualization, then one cannot claim copyright. And the subject matter of copyrights, they're either primary works, and these are original authorship. And they include poems, softwares, sermons, paintings, the Mona Lisa, that painting which you're not allowed to recreate. And those are the now original works. We also have the other category of secondary works. And they're related or allied. And in these, we think about the films, we think about cinemas and sound recordings. So we have rights of copyright, and copyright subsists automatically upon the creation of the work. It need not be granted or registered. The fact that you've done it is enough. It will not need to go to a body to determine, is it novel? You see, in the patents, KPU needs to determine that this thing is unique, it's not been done before. Then once they determine, then they can register, because it's for 20 years only. And KPU will do the tracking and the usage. But for copyright, you need not take it back to anybody. You just need to do it, and it's automatic upon the creation of the work. If it's a painting, it's automatic upon that. If it is a song, and or if it's a novel or a poem, automatically you get that. Number two, it is that it governs both primary and secondary works. We have indicated primary works, the original authorship, and secondary following quite closely. They're governed by the rules of copyright. And more importantly is that the subject matter must be original. It must come from you and no one else. You have not copied, you have not gotten ideas from outsiders. It's simply you. And you remember, if I can't be assisted, if I see you, George, having done something great, and then I keep saying, oh, it was my idea, I had talked about it with George, this is how we are going to do it. You remember, an idea can never be copyrighted. And a copyright subsists for the life of the owner plus 50 years. So if the owner lives up to 100, this one who has written these poems, if that owner lives up to 100, add another 50 years for that copyright to exist. So what do we do when this copyright has been infringed? An infringement is dealing with that controlled work, controlled by copyright, in a manner contrary to the interest of the owner of the copyright, without his consent, authority, license, or permission. And the conduct of that defendant must be seen as to contravene the reserved rights to reproduce, communicate to the public, broadcast, and perform the work. You see, with copyright, you may make copies as indicated. And this is why you find that there are documents you are able to download, but you're not able to convert them into any other format than that which is prescribed. It is the element of copyright, you protecting your original works. If I have come up with a recipe and I intend to share with a few friends, then I put it in such a way that you're not able to copy paste it as easily as you would want. You're not able to infringe on my rights. So how do I prove that I have infringed on your rights, George? One, there must be similarity. It's a matter of fact, and in music is difficult. This is probably why we are hearing currently in our country that old song that past generations were used to. So when it's put on, they assume it's that song. But in reality, it's a new song by a newer individual. You hear that the beats are similar, the words are different. And this is why we are saying in music, it is extremely difficult. There must also be evidence of access. How did I come to know you painted that Mona Lisa? You must have invited me to your home, shown me where that painting is hung. So should anything happen, we determine it as infringement of a copyright. Once I come up with a drawing so similar with that one of yours, people may be unable to differentiate which is the original, which is the correct one. And the defenses that we have to infringement is that it's fair dealing, where you use work for criticism or review or private use, and you're able to tell the court, no, I did not use it for any other thing, but I have done that to review, to give feedback on how it should be done. Then it's a defense if the copyright is used for the benefit of the public. Then you cannot again plead differently that my copyright has been infringed. And the remedies include an injunction. Stop using George's poem. Stop quoting him and not recognizing the source. And number two is the damages, whereby I'm restored. People assumed that this is the Mona Lisa. You duped people, and you have put my character into, you have assassinated my character. Then I will need you to restore me to the position I would have been had you not infringed on my copyright. We then move to trademarks, and these are words or signs to indicate the correlation between goods and services and the owner. It's a distinctive symbol that identifies particular products of a trader to the general public. And it may convince of a device, words, or a combination of these two. For the trademark, we are not limited to just use words. Again, we are not limited to just use diagrams. You are given that leeway. It can be anything. And they're granted in order to distinguish between the services and the provision of goods. So the examples of trademarks: the Toyota logo on the car, or the Mercedes signage. Then we have headings and titles on products or papers, how they are done, how they are able to be rephrased. And a trademark, remember, copyright, we have said whether or not you register it, it exists. The patent must be registered, and a trademark as well must be registered. And they register by sending a written application to the registrar, and the registrar will advertise that there's an application for a trademark. Then he will look at the opposition, and within 60 days, you'll have your solution. You'll be able to proceed. So why do we use trademarks? And one is to distinguish the goods of another traded from those of another. Pepsi and Coca-Cola, Miranda and Coca-Cola. You're able to differentiate based on the shape of that bottle and that unique taste. You use trademarks as well to refer to a particular quality. When you talk of designer bags and you associate Gucci with class and expensive goods, it gives it more weight, that you only need to remember how Gucci looks like, then you're good to go. Trademarks also protect the investment of the inventor. And it's also used to promote the marketing and sale of a product when one has a trademark, such that if I see you walking with that soda that has that unique shape, I would want to also find out, are all of them that way? Are all of them shaped in that manner? The shape has attracted me to your soda. And we talk about trademark infringement, and that is the use without license or approval. And what our defense is where we say there's no title, the trademark. It's not yours. So you cannot again go back and sue me for using it. If it's not yours and it's not mine, then that's another issue altogether. So where you have not registered a trademark, that is a defense to the infringement. So we talked about that promoting and marketing when one has a trademark. The shape of that bottle, the taste in it, it becomes the basis of marketing. So in the infringement, we talked about the non-registration. If you don't register it, then you cannot sue for infringement. Again, there's the non-use of the trademark, where I may have registered it, but I haven't used it in the sense of that trademark. So those are the defenses in the trademark in infringement. This is what we are saying, that the trademark is used to distinguish the goods of one traded from those to another, particular quality. It protects the investment of the inventor. the labor capital as well as the goodwill, although that has been questioned to have no legal basis. And it's also in identifying the origin of a product, where we were talking about Gucci shoes, automatically you know where to get them. When we ask ourselves, what is the role of professionals, advocates or certified secretaries in land transactions? Advocates perform the due diligence. They will go do a search. They will identify whether you have a clean title. One, whose name appears on that that title that we have presented to you. If it's George, good, issue number one resolved. Number two, are there any, remember, we talked about encumbrances. So does that title have any charge or any mortgage attached to it? The advocate will be able to identify and show you how best to deal with such an issue. Because if it has been used to secure a loan, then the owner cannot sell it until they have cleared that loan and again gone back and said, we clear the charge from our title deed. So the advocate also provides guidance. They also they witness the signing of the sale agreements. One, they draft the sale agreements and they have the terms and conditions that if you're selling your land, are you selling with all that is on it, or will you be given time to harvest? Again, that advocate, once they write down that sale agreement in land, then they provide for ways of resolving disputes. That before you and I are very annoyed and we don't want to deal anymore, we remember that the sale agreement we signed provided if we can't get along, we will need to go for alternative dispute resolution. And it will have saved us both the embarrassment, the issues that may come with refusing to honor the obligations of that sale agreement that we sign. So that essentially be the role of professionals. They are giving advice, they are following up to ensure that the title is clean, it has no encumbrances, no issues attached to it, there are no relatives fighting for that piece of land. And once the sale agreement is done, the money has been exchanged, and the one selling has given out the title deed. So for the one buying, again, must take that title deed, attach the relevant documents, go with it back to the registrar so that the records are changed. They reflect the buyer. They no longer reflect that seller. So these are the roles of advocates, to ensure that you are not sold ideas and dreams. That whatever is being sold is physical, can be touched, can be seen rather. So advocates provide due diligence in these transactions, and where there is that element of the money will be paid in stages. If you went and you got a piece of land, someone sold you a piece of land, but unfortunately you come and realize that the piece of land never existed. You are actually taken to view someone else's home. And you take this seller to court, and the court determines that they will recover the money. That part of the damages we have said, part of the obligations. Once an issue has been found, part of the remedies include damages, and where the advocate will be the intermediary. Instead of sending that money back to me directly, it will pass through my advocate. They will determine whether the payments have gone on as per schedule. Now that you took the person to court, so the advocate will find out, are these issues being sorted out as they should? And how are they being done? So they provide that guidance. They provide a way forward of dealing with things. And having said that, we have come to the end of property law, the law of property.